Docket number SJC-13552, Commonwealth versus Latarsha Saunders.
Okay, Attorney Shaw.
Chief Justice Budd, and may it please the court. My name is Robert Shaw. I'm privileged to appear today on behalf of Latarsha Sanders, and I'm privileged to do so with her family, who is present today in support of her. The trial judge's wholesale exclusion of clinical evidence in the form of medical records and testimony about them was a clear error of law. Chappelle did not support it. Goddard did not support it. Defense counsel repeatedly sought introduction of medical records through 7 volumes of transcript, yet the judge prohibited that evidence from reaching the jury. Now, what the court is being asked to do by the government in this case is to rule in a manner that would undermine decades of law and literally flip it on its head.
Mr. Chair, can I ask you about the prejudice prong of your argument?
Sure.
As I read through the record, probably not as carefully as you, but as I try to look at the record on the procedural part of it that both you and the Commonwealth laid out on this issue, there seems to be at least some waffling by trial counsel as to the need for these records. I mean, there's a pretrial conference portion where he says, maybe all I'm looking for is what ultimately happened. And then there's one part of the transcript where maybe it's capitulation, but the defense attorney does say something like, well, what I can do is ask the doctor X, Y, and Z, did you rely on these records and the like? And that's on volume 6, pages 140 to 141.
So, Your Honor.
So, assuming, and I think it was preserved, that he asked and the records were excluded.
Sure.
But this more goes, in my mind, to the prejudice prong of your argument where the judge may have said, well, there were portions of the argument where the defense attorney said, what I'm really looking for is this, and that's what he got. So could you address that for me, please?
Yes. So to begin with, the language being relied upon by the government pre-trial is taking place pre-trial, and it was not intended to limit the evidence. And that is made apparent by his multiple subsequent requests through 7 volumes of transcript. It's made apparent by his opening statement. You can see from his opening statement, which is subsequent to that he believes the medical records are coming in. Now, I think you have to look at that language in context, because in context, what the judge is doing at that point is suggesting that, well, maybe you could reduce the volume of the number of medical records. There's no issue at that point about excluding the medical records. There's no indication that the defense expert is not going to be able to testify. And in fact, there's not even an objection at that point. And defense counsel's response is to say, I'm happy to refer to the medical records generally when discussing the expert's opinion. He's saying he's not going to refer to all of the medical records one by one. He's saying he'll do it generally. He's not saying that I'm not going to have his expert testify to the details of the medical records. He's not saying that he's not going to introduce them. So, at that point, there's not even an objection. And, was the language imprecise? Yes. But I think when you look at the record as a whole, it's clear he wanted the medical records in. Now,
and relate that to prejudice, please.
Yes. So the prejudice here is enormous, all right, because the sole issue in the case is criminal responsibility. These records supported severe mental illness. They were a critical foundation for the defense expert's independent conclusion that Ms. Sanders suffered from an underlying psychotic disorder. And this is just the same as it compelled the government's own expert to conclude that she suffered from paranoid schizophrenia and that she was highly likely symptomatic at the time that this occurred. So it's simply wrong that the jury never heard the evidence, and it would be fundamentally unfair to conclude that the government's post-conviction narrative about these records can substitute for jury's informed judgment, or for the court to substitute its own judgment for that of a jury.
Well, that's what we do, though, when we review for prejudice, right? We do substitute our own judgment for what the jury would have believed had they had the particular evidence that was excluded. That's part of our review.
Well, I guess it depends. I mean, here you can look at the volume, the immense amount of information that the jury didn't hear. I mean, at some point,
we are making that call, just to be clear.
right. But in other words, I just think that from case to case, you get past a certain threshold where it's just not appropriate for the court to act as a jury would, and say, notwithstanding, this extensive evidence that's been excluded, we're going to find that we don't think it would have made a difference. Now, with respect to your question about defense counsel and his ability to make superficial reference to information, evidence that he wasn't able to introduce. No, I don't think that diminishes the prejudice. I mean, defense counsel was placed in a position of trying to salvage a defense that was essentially gutted by the trial judge's ruling, and he was relegated to making superficial reference to evidence that he couldn't introduce. And that's really not sufficient. It's a lot like saying to a defendant who wants to mount an alibi defense that, well, you can mount an alibi defense, but you can't tell the jury where the defendant was or who the defendant was with. And then the defense counsel tries to do his best with that by, in closing argument, simply referring to the fact that the government didn't dispute or present opposing evidence to counter, his bare naked assertion that there was an alibi. But, you really can't say that is not prejudicial. And there is an enormous amount of information in this record. That information is the essence, it's the heart of the defense in this case.
Can I ask you a question about that, please? So it seems to me that part of your argument is premised on a certain understanding about how Section 79 works. And I'm trying to make sure that I understand what your position is about Section 79. It seems to me you're arguing that because Section 79 makes the records admissible, they therefore would have been admitted in their entirety. And so when you refer to the sheer volume of information that didn't come in, that argument seems to me premised on this understanding of how Section 79 works. But that understanding of Section 79 seems to me to remove any discretionary function of the judge. So can you please tell me, first, is it your view that Section 79's making of the records admissible is the same as sort of automatic admission of them?
Well,
and if that's not your position, do you agree that there's a discretionary role for the judge? And then the third level to it is, assuming you would agree as to both of those, then what do we do with the fact that none of that happened here? In other words, how are we supposed to guess? Maybe there are things in here that genuinely, if the judge had taken a look, or if the judge, in other words, why is it that we're supposed to assume that it all should have come in?
right. So, Your Honor, first off, the statute says that medical records shall be admissible.
They're admissible.
Yes,
right.
they are admissible, and the judge has a role.
There's a difference
discretion.
between, right.
I'm not asserting that the judge has no discretion, but the judge's discretion has to be guided by the statute. And the statute lays out fairly clearly, they shall be admissible. They're not hearsay. There isn't an authentication issue. They come in for their substance. There are certain limitations. If they do not concern medical treatment and history, then they don't come in. If there is a question directly to the issue of liability, then they don't come in. If, for example, there was some third-party hearsay that had no relationship to medical treatment, obviously the judge could exclude that. So there is a role there.
So then wouldn't it be more correct to frame your argument as saying that the parts that would have been admissible, because you're just pointing to the entire mass of the record.
Well, Your Honor, I mean, defense counsel wanted the record in because his expert was going to testify about all of the information in this record, and he wasn't going to be cherry picking it. He raised this issue pre-trial. The Commonwealth didn't object until the 6th day. The judge didn't rule until the 7th day of trial. So defense counsel wanted to get this in. He had provided his slides weeks before the trial. So the government knew the areas that the defense expert was going to focus on, and yet no specific objection was raised. And it's the Commonwealth versus Francis in the statute itself. It is the government's obligation to raise a specific objection. Now, one of the things that happens in this case is that the government in their appeal is attempting to reframe the judge's ruling as based on relevance and appropriative prejudice analysis, assertions that are contradicted by the record. He rejected relevance entirely as a basis, and there was no prejudice probative analysis. And if you want to look at the sporadic discussion that occurred before the judge's ruling, and his ruling really made much of that discussion moot, but there was a lot of back and forth piecemeal discussion that the government hadn't even objected yet. His errors are numerous. He's misapplying Goddard and Chappelle. He's disregarding 23379. He's equating medical diagnoses with testimonial hearsay from an NME or a DNA expert who isn't present to testify. He's improperly barring diagnoses, suggesting they're not admissible in medications. He's suggesting the need to produce the CVs of all of the treating physicians that are mentioned in the medical records. That's never been a requirement. And he's improperly placing the burden on defense counsel to call witnesses he had no intention or obligation to call. In the government's case, they then attempt again to sort of blame defense counsel for trying to salvage his defense. And as I indicated early, in essence, what the government is doing is they want the court to ignore the judge's error, and they want to focus on what defense counsel did or didn't do to ameliorate the prejudice of that error. And that was not his burden, and that was not his obligation. And we don't address judicial error by focusing on how defense counsel tried to compensate for prejudice caused by an improper judicial ruling. So on this issue, the judge's ruling was a significant error of law resulting in errors of judgment when weighing factors relevant to his decision. And we assert that the wholesale exclusion of medical evidence deprived Ms. Sanders of a meaningful opportunity to present a complete defense. Now, with respect to prosecutorial overreach.
Kim, before you, I just want to, go ahead.
I had one more question too before you went to another. So one of the arguments you make about prejudice rests on the fact that the Commonwealth did not choose to call its own expert. Commonwealth was not under an obligation to call its own expert, correct? And what prevented defense counsel who knew of the Commonwealth's expert's opinion from bringing that person into court to...
Your Honor, nothing prevented defense counsel from doing that, but you know...
So how can all of these strategic choices then be the basis for a prejudice argument now?
Because, well, Your Honor, a couple of things on that. But first, with respect to defense counsel, he wanted to call the expert witness, but he didn't want to be boxed into asking direct examination questions. And for those of us who practice in the trial court, there is an enormous difference between being able to cross-examine somebody or really challenge them or preparing them and going through a direct examination.
Sure,
so he
but
couldn't
then-
do that.
But then the Commonwealth is entitled not to call.
I understand.
Right, so how does that all become prejudice?
Well, again, it just contributes to what happened here, because think about what the Commonwealth is requesting here in terms of interpreting the law. They want to render 23379 without force, so this stuff doesn't come in, despite the fact that it's admissible. And it would allow prosecutors to exclude medical evidence that is admissible but unfavorable to them by declining to call their own expert and not opening the door on cross-examination. So the prosecutor effectively limited this evidence from coming in, and the jury hearing it because of this judge's ruling. She was moving to exclude all of this in totality. She did not want the jury to hear this medical evidence or to have the defense expert testify about the basic foundation for his opinion and substantive evidence, observations, diagnoses, longitudinal evaluation of this woman. There are over nearly 600 references in those medical records to schizophrenia and schizophrenia spectrum disorder.
At what point during the trial, in your view, did the judge's ruling regarding the medical records not coming in become, let's call it, final? In other words, it wasn't still under discussion.
Oh, well,
point?
It became final on the 7th day when he issued his written ruling. And his written, and you can...
And at that point, had the Commonwealth rested?
I don't believe, I'm not sure if...
See, if the decision not to call their expert preceded that moment, then I'm not sure how all of this argument really ties together, but...
I guess I'm not following why. The judge did not allow the records to come in. He's not allowing the defense expert to testify about them. The government was not going to call their own expert because their expert found that she suffered from...
Sure, but I'm just trying to get at, if in terms of your argument about prejudice, and I don't want to belabor this point because your time is limited and I know there are other questions.
And I had a follow-up on the government's expert was Fiore, is that right?
Yes.
So, and there is some testimony about Fiore, and how did that get in, and what was it? Because I understand it closing...
There was no testimony about Fiore. There was information that defense counsel was reciting what she actually found when he was arguing that medical records should come in.
I'm just, in the closing, the defense counsel suggests they would have called Fiore, right? Right? No, he was suggesting,
he was trying to do his best with what he had, and he was suggesting that the treating physicians, that they would have called somebody from the medical records if the medical records would have helped them. I mean, that's what he's left with.
No, I'm not, I thought it was pretty effective, but I'm just trying to understand the basis of, I thought the defense counsel said the government didn't call its own expert.
Oh, I guess I'm not recalling specifically.
I
they
think
have said that, but
I'm
they
just
didn't.
Trying to understand how he could have done that. There must be some evidence some evidence at trial that allowed him to do that. That's pretty good,
Well,
right? That's the Commonwealth doesn't put on an expert, and somehow the defense counsel in closing is able to say, Commonwealth interviewed somebody and clearly came out the wrong way for them, right? I'm just trying to understand how they got into that.
Yeah, well, I think that he was just asking. All he had to deal with was what was not in the record. Okay. He had no affirmative evidence.
I am quite concerned about the law and order special victim stuff.
Okay. Right. So if I could get into that very quickly, the central theme, the central lens through which the prosecution asked the jury to understand what occurred was that Ms. Sanders is evil. The absolute reality is a simple explanation, the prosecutor says, and that is that she is evil.
I understand where the evil stuff comes from. I'm more concerned about that.
Well,
go ahead.
Right, and it's related to that with respect to the prosecutor mischaracterizing the notebook, jail calls, scene evidence, and interrogations of Miss Sanders, yes, the prosecutor raises this law and order SVU issue.
Yes, at trial, she asked one of the police officers about the video that was on TV.
And the police officer couldn't say what it was.
And then she asked the officer, are you aware that there are 4 episodes of this where someone kills their kid and
Right.
brings up the voodoo stuff?
Right. So there
Is there any basis in, when she does that,
no basis whatsoever.
is there an objection to that during the closing?
I don't believe there was an objection at the closing argument stage about mentioning the film, but there are really 3 errors that relate to the law and order SVU. Number 1, that it was on television at all. There's no basis in the evidence for that. That there was any particular show on, much less law and order SVU at the time the children were killed. There's absolutely no evidence of that. I mean, the crime scene video is being taken, maybe a day later, certainly hours and hours later. And then on cross-examination, the prosecutor suggests, without any basis in the evidence, that there are 4 episodes of Law and Order SVU where a mother kills her children and then claims voodoo. Now, that was entirely manufactured. There's absolutely no evidence of that.
And Dieters didn't agree to that, correct?
Well, I mean,
he says he doesn't, I don't know.
He said he didn't see it. Yeah, she said, did you see that on the television? So she tried after.
A question is in evidence.
Right, she tried to elicit it from police officers. They said they didn't recognize Law and Order SVU. Then she said, did you see that on the television? He said, no, I didn't see it. And then she said, oh, so you're not aware of Law and Order SVU and, 4 episodes of mothers killing their children and claiming
And
voodoo.
does she bring that back up in closing?
Yes, she did. I mean, Law and Order SVU was part of this supposed motive, that she got the idea because, in closing
By the way,
argument.
there's nothing in our record to know whether this is true or not. Whether there are 4 episodes of this voodoo.
There's no evidence of it, and even if there's no evidence that Latarsha Sanders, assume there was, even though there isn't. There's no evidence that Latarsha Sanders saw them.
I take it the Commonwealth's going to come up and argue that she's weaving this voodoo stuff into what she tells the police officers of why, right? There's the voodoo. She brings up voodoo in her statement when she's being questioned by the police officers, right?
Yes, and I excerpted a lot of the statements, so there couldn't be any cherry picking, and you could see whether it made any sense.
The jury saw that whole. You give us 5 pages of, and the jury saw all of that interview.
They saw the interrogation. Yes.
On the issue of evil,
Yes.
it's mentioned by the defendant a few times. Is there a distinction between use of that term as far as a defendant's professed belief system or use of that term versus asking a jury for its moral condemnation of the defendant?
Well, I think the problem here is that what the prosecutor is saying to the jury is that she is evil. She, the person, is evil. You should disregard mental illness and.
So you're saying it's moral condemnation, not proper use?
Well,
could that term be used properly in a closing argument?
not if it's focused on the person and it is.
What about the
character
person's
attack.
belief system?
I'm sorry?
What about the person's belief system?
Well, I mean, I don't think there's any evidence here about a belief system in the jail calls that are being cited, and this is part of the.
Well, it's an inexplicable crime, and then she at some point mentions, it could be the work of evil, correct?
No, she doesn't say that, Your Honor.
Give me the context then.
Yeah, so what the government is relying on are 2 jail calls that occur on a single day where she mentions the word evil.
She connects it to herself, right? Be specific.
Right, so
She doesn't, she says the evil in me or something like that.
No, she says she had the evil in me. During the jail call, she's actually suggesting that she was able to expel it from her body by urinating. So she's not saying I am inherently evil. She's saying I had the evil in me, as she's trying to
I
understand.
haven't read the whole statements, but what I've read in the briefs doesn't have the urination point.
Well, my reply brief does, Your Honor.
Okay, but she says, again, this is in the light most favorable to them. She says, she uses this term in describing herself and having these evil episodes, right? Or, I mean, I'm not, I don't want to overstay. I just would like to be precise if we can.
Yeah, well, I'm trying to be precise, Your Honor. She uses the term, I had the evil in me this morning. I mean, it's a colloquial way of saying that she was having a bad morning, or let's say she's,
That's in the light most favorable.
let's say she's referring to the fact that she had evil in her. Does that give the government then the right to have the equivalent of a Salem witch trial where in a murder?
They have the ability, the standard has a moral component to it, right? Can she separate right from wrong?
Your Honor, is the issue going to be, is Latarsha Sanders evil?
No, the issue is going to be, can she separate right from wrong? The proper standard we're applying, which is what is the right or wrong in the standard? What is the language we're interpreting?
It's both legal and moral.
Right.
The first prong of McCool has both a moral and a legal component to it, correct?
Yes.
And then the second prong is ability to
being able
conform
to
your
tell
conduct.
right from wrong, but
Right, in a moral and a legal sense, or a moral legal sense.
So how does that permit character attacks?
That's what the Commonwealth, that's what the prosecutor tries to do. Whether she does it fairly or not, we can.
Yes,
we
I
have
mean,
to
I
start,
don't-
but she does say that the defendant understands the difference between good and evil. She even says it about herself, right? That's what the prosecutor does in closing.
Well, what she's doing in close is she's saying the absolute reality is a simple explanation for why this happened, and that is that she is evil. And this was, these were assertions.
What page does that sentence appear that you just said? As I'm looking at the closing right now myself,
Unfortunately, I don't have it right.
it's important. Words
Well,
matter.
It's cited in my brief.
I know. So, right. So my question is, can you point to a specific portion of the closing where the prosecutor went beyond the evidence in her use of the word evil?
Your Honor, evil is a metaphor.
Because there was evidence where the word came up. And so I think in closing, the question is, if she stayed within the bounds of the evidence, then it's harder to make your argument. So I'd like to know where specifically the prosecutor went beyond the evidence in her closing
There
with
is an
respect to evil.
Well, I filed an opening brief and I filed a reply brief, which I think you both have. Those have all the citations to the record. But the bottom line is that there is no evidence from jail calls on a single day that Latarsha Sanders is evil. And somebody being evil is a metaphysical question that is non-justiciable, and it is not appropriate for a prosecutor to get up in front of a jury and, rather than looking at evidence and facts and then drawing reasoned inferences from that evidence and from those facts, to simply argue that the explanation for why this occurred is that Latarsha Sanders is evil. That is inappropriate. That is an improper character attack, because it is improper to say that the reason this happened arises out of the fact that that person is evil.
I do see that here. Looks like it's page 58 in the closing. Okay. I think.
Okay. Thank you, Your Honor.
Okay, Attorney Weisgold Johnson.
Thank you, and may it please the court. My name is Melissa Johnson. I am an assistant district attorney in Plymouth County on behalf of the Commonwealth today. If I may, I'd like to start with the closing argument issue raised by my brother, and specifically.
Actually, before you do that, can we just talk about the medical records?
Absolutely, Your Honor.
I just want to know if you agree that the judge abused his discretion in failing to allow any of the records in.
Not only did he not abuse his discretion, he knew exactly what he was doing, and he did it correctly. But in the end, the defendant got exactly what she was asking for.
Can you go through and explain how he did it correctly and
Yes.
not allowing any of the records?
Absolutely, Your Honor. So the very first pretrial conference, the defendant put forward that she wanted the medical records in because she wanted her expert to rely on them. That's all. He just wanted Dieters to testify that he reviewed a particular report and relied on it for his opinion.
Did you concede that the defense attorney moved for the records to be admitted into evidence?
Yes,
Okay.
at some point, because
Well,
I think-
then it doesn't really matter what happened at pretrial conference. I know there's some wishy-washy part of the defense attorney's presentation,
there was
but there were two
definitely-
portions, as I read the record, where he said, I want these records in. The judge said, no, you don't, correct?
Yes, that's true. I think he was kind of hedging and going back and saying, and he said it a couple of times, I really just want my expert to be able to say that I'm relying on these records. And he said no less than 4 times, look, I've subpoenaed the clinicians from Worcester that have.
If there were 2,000 pages of records that have references to psychosis and schizophrenia, how is that not prejudicial?
It is not prejudicial, Your Honor, and I've gone through, it's actually almost 3,000 pages of records. I've gone through them page by page, and I am confident that when this court reviews them, you will see on balance that they were actually more harmful to the defendant, because for at least 5 months after she murdered her children, there was no notation whatsoever, no observation, no clinician had a report on any kind of psychotic behavior. It wasn't until over a year and a half after this happened that there was any kind of diagnosis that included psychotic features.
Commonwealth's position is that the defendant was not mentally ill, correct?
That she was not criminally responsible.
And not mentally ill. You said that, well, your prosecutor said that the reason she did this is because she was evil, not mental illness, correct?
Yes.
All right. Now we have 3,000 pages of medical records where we have diagnoses of mental illness, which bolsters what Dieters has to say.
I would respectfully disagree that they do not bolster what he has to say, because in fact they don't support at all. The whole crux of his testimony was that she was suffering from some kind of prefrontal lobe disorder or dysfunction. Nowhere in those 3,000 pages of records, when clinicians have been observing and evaluating this defendant over a period of about 2 years, did anyone ever mention a frontal lobe dysfunction? And this was the cornerstone of Dieter's testimony. So in fact, those 3,000 pages would have undermined his testimony. I think in the end, it would have been more harmful to the defendant. And particularly if you read the records, which I would submit are more relevant from MCI Framingham, which are closer in time to the incident. Throughout those records, there is no mention for months of any kind of psychotic behavior. And that's really what the jury is going to be looking at, is what is happening close in time to the incident. Yes, 19 months later, over a year and a half later, there are some diagnoses within there that incorporate some psychotic evaluations or psychotic diagnoses.
Do those relate back in time, describing this illness as something that's going to manifest, that it's not out of nowhere, right? Are there, I mean, I haven't read these 3,000 pages yet, not looking forward to it, but is it going to say that this type of mental illness is something that would have been around a long time, anything like that? Or is it going to just not try to trace it to cause? Because your own expert didn't testify and couldn't make a judgment call about whether there was a mental illness at the time, apparently. So that gives me some pause here.
Well, if I may, Your Honor, actually
The
what
fact that you couldn't have anybody testify, it's like interesting.
because the actual evidence of what she did and said on and around the time of the incident was so powerful that we didn't need to.
I don't know, I've read the interrogation stuff. It's either she's a very good faker, which is possible,
Right.
or that we're having some kind of really disconnected thinking here. Right?
Well, if I could address both of those issues. As far as the interrogation, what is quite compelling about that is she immediately blames her son and the son's father for it. And she describes in detail what happened. And when the police are pushing her, well, why don't you have any injuries? Were you trying to stop what's happening? She immediately was able to turn around and say, well, they jumped on my back. And when they asked her...
Your brief sort of presents a coherent kind of, alibi defense. When you actually read the thing, it's incredibly incoherent. It may contain this in the light most favorable to you, but it's hard to follow.
Right, but at every point when the police were pushing her on, well, why didn't you use your phone? Well, my phone wasn't working. So she clearly was able to conform her conduct, to appreciate what she had done. If she wanted to, I suppose she could have said right away, I don't remember anything, or the TV told me to do it, Illuminati told me to do it. She could have said that right away, but instead she crafted this entire story about how someone else had done it, and she had tried to stop it, but she couldn't for all of these reasons. So she was clearly able to function and articulate a sort of excuse or alibi for her behavior. She understood what she had done. But back to your question, as far as I think you were asking me whether there was some sort of longstanding psychosis, I think that's what the Worcester clinicians were struggling with, because here she is in her mid-40s, and all of a sudden this is materializing. And as your honors are familiar,
Do they struggle with that in those records?
they do.
Okay, but that's both helpful to you and helpful to him, isn't it, too? Meaning, if they're struggling, there's a possibility that it was present, right?
And that's exactly what Dieters was able to testify. He was able to parse out the findings that supported his opinion. So in the end, the defendant got what she needed. She got the findings.
That's a prejudice argument, correct?
It is.
Okay.
It is.
Now, the first step is whether there was legal error.
Yes.
As I read Chappelle, it actually says the opposite of what the judge ruled. So how is there no, you're not conceding legal error, correct?
No, absolutely not.
Okay, then how are these records inadmissible?
So the way I read Chappelle, I think the judge did exactly what he, within his discretion, was supposed to do. So first he decides, I'm going to exclude these records. Some of them are not relevant. Some of them are misleading.
Chappelle, the defendant didn't wish to introduce the records.
Right.
They were admissible, and the court says, you should have introduced them. You didn't, so you're out of luck. This is the opposite of Chappelle.
Well, actually, the judge, when he decided I'm not admitting these for various reasons, he said, but you can rely on them because they would be independently admissible with the appropriate foundation, with the appropriate witnesses. That's exactly what the judge decided. Now, the judge had the
Independently
discretion.
admissible under Section 79.
And the difference with Chappelle is that the records, I believe, that defendant should have introduced were records that predated the charge. And so there could have been a presumptive reliability.
That goes to relevance.
Right.
Right. And this judge, as I read the record, says they are relevant. So that's out. You're out of luck on that one.
I think he was concerned with the reliability. You could see him struggling with.
Which is a confrontation clause issue, correct?
No, because the Commonwealth doesn't really have, unfortunately, the right of confrontation.
Correct. That's why there's a legal error
But
here.
it's the reason why the reliability is because the statute going way back to Bushy versus Murray, that first case that really interpreted the statute, it's not a carte blanche to just, here's the 3,000 pages, go at it. And
We don't have a judge going through the records to say this part was admissible, this part wasn't admissible. He excluded them.
but the parts of the record that the defendant wanted to highlight in those slides was specifically the Worcester recovery evaluations. And that's really what the defendant.
Where is it that where in the record does the judge go through those records and make a thumbs up, thumbs down determination about what's admissible and what's inadmissible under 79 or 79E?
In that written pre-ruling or preliminary ruling, he does go through the slides.
Right. When he goes through the slides, he says it's not admissible unless you bring a witness in.
Right.
Would you agree that Rule 79 or 79E, I forget the rule for medical records, eliminates the requirement to bring a live witness into court? That's the whole basis of the statute.
You're absolutely right, Your Honor, but there is still, as Justice Wolahojian had suggested, there is still a room for discretion. And I would point this court to, I found very helpful, Commonwealth versus Waite, which I cited in my.
But the problem is that's not how this case was tried. The judge didn't say, I know under Bucci and the cases of liability and third-party hearsay and treatment versus not treatment, there's none of that analysis for these records here.
He may not have done it explicitly, but if you read how he is going, and this is over the course of 5 or 6 days, what his concerns were, they're exactly what was addressed in Waite and what was addressed most recently in Commonwealth versus Chisholm, when you're talking about the presumptive reliability of mental health records that predate the charge versus those.
Chisholm has to do with the mental health exception to hearsay rule. It has nothing to do with Rule 79.
There was a discussion.
Or Section 79.
There was a discussion.
I'm kind of familiar with Chisholm.
I know, Your Honor, and I found that case incredibly helpful in terms of talking about the presumptive reliability of mental health records that predate a homicide versus those that are after the homicide because of the motive to malinger or whatever. So
the motive to malinger and all that is our case law, Panadosi, CYS versus Juvenile, Hamey.
yes.
Those cases all deal with statements made to the expert witness. Most recently in Rodriguez, where he said those records are unreliable because they're made for court, as opposed to treatment records, which we have here.
But there should be a distinction, number one, between treatment records that predate a homicide and ones that post-date a homicide. And I will add,
and that would be relevance.
Right. And I would add.
And you're out of luck on the relevance determination.
I don't think I'm out of luck. First of all, Your Honors can affirm on any ground that you want to affirm on, Your Honor. But I don't think I'm out of luck because it was something that the Commonwealth brought up, especially with the later records from Worcester.
Okay, on page 137, volume 6, the trial judge addresses relevance. And he says, let's assume that a doctor says these are relevant, which is Dieter's. If there's no other objection, I would allow those in. He finds that they're relevant. And then he looks at other objections and he gets into the stuff about Goddard in the basis of expert witness testimony.
But you could still find that they're not relevant, and certainly the ones that are further away in time. But back to the point as far as looking at these records and seeing whether they have those characteristics of presumptive reliability that is envisioned by Section 79. I do think that the judge properly exercised his discretion in trying to figure out, I'm uncomfortable with these diagnoses. And by the way, the defendant wanted to get in her court-ordered eval under Section 18A, which I believe under Rodriguez, if it were just by itself, would.
Well, that's different, though. A court-ordered evaluation is not a defense expert evaluation under Rodriguez. I've seen lots of cases tried where court-ordered evaluations do come into evidence.
But as it's not going.
But usually competency evaluations and the like.
But they shouldn't
Section
for the
7s.
reasons that were stated. basically.
Much different. A court-ordered evaluation is ordered by a court as opposed to a defense expert, which is not reliable under Rodriguez.
And she fully knows that she is in the legal system. She's aware of what is going on, that these things have legal implications. But beyond that, the judge is trying to make a discretionary call as to whether these records going to a jury are reliable or whether it would be better for a live witness to be cross-examined. So there, all these evaluations
How
are
does
going-
that? So I'm trying to actually figure out the Commonwealth's position as to, because now it's no longer clear to me, as to the basis upon which the judge actually excluded in toto medical records that were admissible by statute. Can you tell me what exactly is the Commonwealth's position as to the basis for the judge's ruling?
As I understand it and reading what he was struggling with, I believe that he found that some of the evaluations, some of the clinical diagnoses within the records should not be going in wholesale without a live witness. He was
Okay, well,
concerned
so that-
about the reliability.
All right, so that seems to me that if that is the basis for the ruling, what undercuts that is the fact that the judge didn't then act consistently with it. He did not look at those specific parts that he's making, in your view, in the Commonwealth's view, I don't mean to personalize it, in the Commonwealth's view, reliability determination, and then excluding those. Instead, he's excluding the entirety of this woman's own medical history. And so that explanation doesn't, to be frank, really satisfy me.
Well,
In a case where it's the only issue, I mean, that's the other troubling factor, right? The only issue is whether, she can.
right. But keep in mind that all through this, the defense attorney is saying, I have subpoenaed the Worcester clinicians. They are going to be available to testify. If I don't get what I get out of Dieters, if I don't get what I need out of Dieters, I will have these witnesses available. Now, I'm not saying
But doesn't that go to prejudice? See, this is why I keep going back to Justice Gaziano's first question, or maybe it wasn't the first question, but to actually deal with the first question we're going to have to ask before, or answer before we even get to prejudice, which is whether there was error.
Right.
And that's the part that I really do want to give you a chance to give the Commonwealth's explanation for the global exclusion of otherwise admissible records.
So I think, honestly, the judge was focusing more on the slideshow and those pieces of the records that the expert was highlighting on the slideshow. So he didn't so much talk about the records, but I stand by my argument that he had the discretion under 79 to still decide which diagnoses had those characteristics of presumptive reliability. But beyond that, and this is what I'm struggling with, in the end, he let Dieters testify to all of those findings.
Before you go to the prejudice thing, because is the argument, and again, I'm having trouble following what the judge did, but is it basically that this is so enormous that what the defendant is trying to put in, the records are so enormous that if you just drop in this giant pile, it seems like it's the enormity of it is what's sort of leading him into to this categorical approach. It's so big that I'm going to exclude all of it until this gets refined. Is that
I agree with you. I think that was the very first thing he said at the pretrial conference. Are we really going to to give this entire pile of 3,000 pages to the jury without any kind of explanation or direction or anything. And that was absolutely his first concern. In the end, again, going back to the prejudice argument, I've gone through the 3,000 pages. They do not help the defendant.
Can I shift you, because I know can I shift you to the law and order special victims thing that just seems really troublesome, that this thing not only comes in, but it also comes into the closing too. Why should I not be troubled by that?
Well, a couple
Is it
reasons.
error, right? It's clearly error, right?
Well, first of all, the first thing I'll say is it didn't draw an objection, and sometimes things have less of an effect in person as they might on paper. But I will point out that in the defendant's interviews with the police, especially the second interview, and I believe it was around page 77, I don't have the record site, but I know it was around page 77 of the actual transcript, she talks about seeing something on TV as sort of prompting her to stab her children. And so obviously that now becomes an issue. What was on TV when the police arrived and found these children? And we have evidence.
How much later?
We don't actually know the timing. I'm assuming it was within about 8 or 12 hours, but we don't know for sure. However, the way that these TVs were programmed, as you can see from the photos and from the crime scene video, it was queued up and playing something. So you could see that we don't know whether it was actually playing. I think you can make that inference, but it was queued up sort of to play.
I'm confused by that, meaning like I queue up the news hour every day, meaning that because I was taping it, that means that I was watching it. I'm just trying to understand what the argument is.
It was something that the defendant brought up. That was the only objection, was that, well, we don't know whether it was playing at the time she actually decided to stab her children.
It was in her
And the
queue.
judge said, well, the Commonwealth can argue that inference. And those two programs were playing on the two TVs in there. So she was making an argument from the evidence. Now, it wasn't the centerpiece of her argument, and I would ask this court to, number one, not view that remark or these remarks in isolation, and number two, please look at the context of what the defense attorney argued. The defense attorney is essentially, his whole mantra is, well, she was a good mom, so she had to have been crazy, some general definition of crazy. And here's the prosecutor trying to kind of right the ship here. Now, hang on a second here. We have a very precise legal definition of criminal responsibility that we need to prove. Part of that is showing that this defendant had the wherewithal to appreciate the wrongfulness of her acts, to conform her conduct. So the prosecutor's taking the defendant's own words, own actions, and her word. She said the word evil to describe herself, I think 31.
I'm less bothered by the evil because I understand where that comes from. I'm more concerned about this suggestion about that this is a voodoo killing of children based on 4 episodes of Law and Order Special Victims Unit, when there's no evidence of that. There's no evidence she ever watched those 4 episodes. And the cop who's asked the question says, I don't think so. I mean, I don't know anything about that. So
Well, I
it's
think
like,
it was
it's
Dieters
like the
that was asked the
prosecutor came
question.
up with this herself.
Okay, well, I think it was, first of all, it was Dieters that was asked the question. I don't believe it was a police officer that
Dieters was asked the question?
I believe the prosecutor
I
asked
thought she
him,
asked a police officer. She asked one of the arresting officers, right?
right, what was on the TV. I think it was up for the Stranger Things.
She
but
didn't ask this special victims thing to the police officer?
I don't recall that specifically. I remember the Strangers thing, but I do remember her asking Dieters about the SVU episodes. Did you watch, and she did in the context of, did you even see the crime scene video, which Dieters did not. So that was the context of that question. And the defendant's own defense was all about, well, I'm following the Illuminati, I see these things on TV, I do them. You know, that is her whole defense. And so the prosecutor is trying to show the jury, well, you can have these kinds of belief systems, conspiracy theories and whatnot,
Well,
but you still
the
can
Santa
appreciate
Claus-
the wrongfulness.
Santa Claus thing is out of line too, right? That's just,
I completely, no, I
really?
disagree.
I mean, the fact that we tell our children that we bring them presents on Christmas from a Santa Claus is somehow relevant to this? Man, give me a break.
Well, Your Honor, I think what here, and again, we have to look in the context of what the defendant is trying to argue here. And the defendant's argument was all centered around this general sense of craziness. She had to have been crazy to be doing that. This prosecutor is trying to explain the legal standard here. And she is trying to convey that just because you have these conspiracy theories, it could be, of course, Santa Claus, because
Santa
of
Claus is a conspiracy theory?
Well, it was Christmas time, Your Honor. And I also think that sometimes when you talk about conspiracy theories, you don't want to offend the jury because you never know who is going to subscribe to.
Believing in Santa Claus?
Well, that's pretty innocuous, but there are conspiracy theories that might offend someone. If you talk about, for example, the 2020 election or January 6th, people have different views on whether those were founded on the evidence. So the prosecutor is not going to use those kinds of examples that might be a little bit more incendiary. What she was trying to convey was that you can have a belief system, maybe even a belief system that's not based in evidence. However, you can still appreciate the wrongfulness of your actions and you can still conform your behavior. And that is what she's trying to convey. She is trying to lead the jury back to that legal standard and using the evidence of the defendant's words, her actions on and around the time of this incident, to show that she really was able to appreciate what she had done, what she was doing, despite having this kind of odd belief system. I just want to quickly return back to the issue of the records. I do want to kind of stress briefly.
Yeah, so, yeah, we've talked about it, and then if you've said it already, I think we've got a pretty good sense of where things stand.